that it came back positive for alcohol.
You want to stay sober.
At least,
How many meetings should you be attending?
at least one a day, sir.
So bottom line is you're not doing the stuff to even help yourself right now.
Fine.
Not, no, I'm not,
New one.
I am not gonna even hear that.
Court calls the case, People versus Merrick, Mexico.
I'm what? And right here. Assistant Public Defender, Chinazi Curie, I can rule, Your Honor, on behalf of Merrick Lincecum. Merrick, state your record.
Merrick Clayton Everett, Lincecum. Good morning, Your Honor.
Good morning, sir.
I have before me a plea form that indicates the defendant will be pleading no contest to an added count 3 of retail fraud, second degree, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution at the time of sentencing. That's the court's full understanding.
That is correct, Your Honor. So you understand?
Yes. May I have him sworn?
Raise your right hand. Solemnly swear and affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you have.
Yes, sir.
Now state your name for the record.
Merrick Clayton Everett, Lincecum.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud, second degree. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Sure.
You also understand, sir, do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first is that it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Sure.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
I'm
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Sure.
Signed in advice of rights form, is that correct? Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form.
Understand.
Understand you're giving up your right to appeal of right.
Understand.
Are you on probation or parole?
Yes.
You're on probation or parole at the time of this?
No, this is from 2023, I believe, right?
Yes. But
I was not. I was on probation a little bit after, but
okay, but not at the time. All right, thanks.
Sorry, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Did anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
No.
All right. The court has been handed and has reviewed Washington County Sheriff's Office report for their case number 2353023. Any objection to the court reviewing that report?
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. So I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing will be
July 6th at 9 a.m.
July 6, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you.
Oh, here, bond continues on.
Court calls the case of People versus Robin Hardy.
That's the balance of people.
Good morning, Your Honor. Ashley Hannibal for Robin Hardy, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Who's Ken? Are you paying attention? Thanks. Drop your rags, you're still analyzed. Permission to practice this grant.
All right. We're just requesting an adjournment today. I'm just requesting an adjournment today for plea negotiation.
Do you hear? Ms. Hardy? Yeah, my Cannon's cases.
Okay,
Okay, there you are. State your name.
Robin Hardy.
All right. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned July 9th, 2020.
Your Honor.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls the cases of the people versus Michael Moore.
Your Honor, Raymond Cook for the people.
Billy Gaines, Assistant Public Defender, written on behalf of Mr. Moore.
On all six.
Yes.
Please state your name.
Michael Moore.
Your Honor, we are in the process of negotiations. We just recently received the mitigation letter from, as in this week, received the mitigation letter for us to present to the prosecutor. So we're asking for a short adjournment, maybe 2 weeks, so that we can continue negotiations. And we'd also like to address bond for one of the cases, Your Honor, for all of the cases except for 26 F5-5051. Mr. Moore has a bond of 1,010%. We're asking for a 1,010% bond on that matter as well. If the court would permit that bond, Mr. Moore is stating that he believes he would be able to post all of the bonds and get himself into a substance abuse treatment program. That we have been working diligently to get him in that. There's already a release to treatment on all of the cases. We are working to try to get his holds in Dearborn cleared up. He was able to get one. There's one more that we're still working on that has been a bit more challenging, but he would be able to go to treatment. Your Honor was able to do that.
I'll adjourn all of these to July 2nd. Do the people have anything they want to say regarding bond?
Maybe we have approach because I have something that I think addresses both the adjournment as well as the bond.
All right. Motion for bond reduction. The record should reflect there's been a brief bench conference. Motion for bond reduction will be denied in that case. Court will continue the bond as set. I will adjourn all of these to the 2nd. 9 a.m. Thank you.
All right, thank you.
Court calls case people versus Dean Hodder.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Hodder, Your Honor.
Not sure it's gonna go.
He was what?
Well, it's just a courtroom, I just saw. Your Honor, may we pass this matter? Perhaps he's in the restroom. Yeah, I mean, he was in here.
Over at community.
He was here, yeah,
Sure.
long beard, yeah.
So if he doesn't show up, you can go into custody? Yeah, okay. I'll pass it. It's probably Bellinger. I'll pass it. What are they doing?
Wait, can you see what the next case was, please?
So we can go look for him, Your Honor.
Not telling. Court calls case people versus Lee, Pat.
Back to the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Patton, who's making his way to the podium, Judge.
Public defenders doesn't think find like Lee, that's Lou. Anyways, your name, sir?
DeAndre Fed.
Thank you. What are we doing?
And we're asking for a brief adjournment in this matter to review discovery as well as discuss potential next steps with Mr. Patton. The people have made a waiver offer regarding a potential sentencing issue. That they're agreeing to keep that open.
Correct me.
July 2nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Daniel Healy.
Oh, the people.
Michael Gaddy, public defender on behalf of.
Your name.
Daniel Heelan, sir.
Take your hands out of your pockets, please. What are we doing?
Your Honor, we're asking for a brief adjournment to continue plea discussions with the people.
July 9th.
Support received the bond violation report. Find the budget progress report was done to change the defendant's most recent process is positive for an ATG.
Well, that's supposed to be kept. Did you see it?
Yes, Your Honor, I have had a chance to see the report. I too interpreted the positive for ETG not to mean that he actually just took a test, but that it came back positive for alcohol. Mr. Heelan does, as he just told you, he did drink. He is working. He has a prescription for the other substance that was indicated. He is working to make positive change. We'd ask the court to consider his unequivocal and honest response to the court in regards to the violation, and perhaps give him an opportunity to continue testing, remain outside of custody, and continue dealing with these matters.
You completed Bear River?
Yes, Your Honor. You know, I know I've still made a lot of progress, Your Honor, and I'm not making any excuses, but I'm not using much worse things and doing much worse things. And again, not making excuses. I've just been going through it. I'm still waiting on my place. I'm just right there, and I just got changes on the way. I'm going through it, Your Honor. Again, not making excuses. I own my actions.
I think he is in line for a voucher or
Right there.
a subsidized housing unit, Your Honor. We thought it was going to be Miller Manor, but it appears it'll be Arbordale now. But he is
Where?
Arbordale.
There was a clerical error, Your Honor.
No, I got it.
We've been here a few times over the last month or so. It looks like on 5/14, my notes indicate he had not been going to community corrections. He was ordered to appear in person, and then we understood that he was testing at home of division, but those results were not being released to community corrections.
Right.
Then on the 21st, we're back again. The home of division results were supposed to have been sent over. I asked for a test that day, but the defendant had no money to test. The court was very sensitive to the housing needs of the defendant and did not want to mess those up. So the court allowed him to stay at liberty. The concern of the people now is that we haven't really had any. The tests that we've had since Bear River have just been since the 21st of May. We do have this positive alcohol test, and as sensitive as I am to the defendant's need to secure his housing voucher, the concerns I have are the support that he's getting. It seems like it's not a sufficient level of support to keep him from drinking or using drugs. So I am concerned about his ability to remain compliant with his bond conditions.
Your Honor, he is, as indicated, is working with Home and New Vision according to the bond report. It appears that Home and New Vision has released the results to Mr. Heelan, and those have been sent over. I didn't quite understand the language in the bond a report that they will have to apparently go through. The way I read it was they'd have to go through Home and New Vision to him to community corrections. I don't know if that in fact is the case. I don't know if they would perhaps agree to release them to me so I can send them along. But that was a bit of an unusual circumstance when I read it, and I got it yesterday afternoon, so I didn't really have a chance to follow through.
I tried to get them released there, so I'm trying. It's a headache. I'm trying to get them to just straight release them off.
How often have you been drinking?
Not often, Your Honor. I was actually just
Well, no. Listen to me. How often are you drinking?
not often, like a couple of times, period. Like, I'm not a big drinker, Your Honor. I'm just, I'm trying, you know, I'm trying so hard. I just, going through it. It was a 1 year anniversary of my father passing, and I'm not making excuses. I went off the hinges a little bit, but I'm trying to keep moving forward. Again, I haven't gone back to the worst things, and I'm proud of myself for that, but I was very disappointed in myself.
What type of treatment? You're at home in New Vision. What type of programming are you in over there?
Intensive outpatient. I see Elizabeth Aoki specializes in intensive outpatient treatment. I just really started with her. I'm just
How often are you seeing her?
Once a week, sir.
Anything else during the week?
I've been attending some meetings. I'm trying to find some.
How many supposed to attend?
I mean, I don't have a supposed to, but I should be going to one.
You want to stay sober.
At least
How many meetings should you be attending?
one a day, sir.
And how many meetings have you been attending?
About one every 3.
So bottom line is you're not doing the stuff to even help yourself right now.
I need to step it up. I need to step it up.
So if you've been doing this, tell me why I shouldn't put you in jail today.
It'd be counterproductive for me just going to jail.
Well, what you're doing is your life is counterproductive right now.
Still making some positive progression. I am making positive progress, and I'm trying hard.
Where's your housing thing right now?
I'm right there. I've just did the new referral packet. There was a clerical error. They didn't have units available, so I kind of had to start over, but I'm right there. Like within the next week or 2, I'm going to have my own place. For the first time in a long time.
You don't get that housing, that's going to be an absolute disaster for you, isn't it?
Yes, Your Honor.
Even more so than what you're doing with your life right now.
So bad, you know. I just want my own place so much. I'll be able to work. I'd be able to take showers and actually be able to function. Just want my own place so bad.
Why are you messing it up?
That's $1 million question, Your Honor. But the flip side of that is I know it's a mess up, and I am honestly reconciled with myself, and I'm trying. And I've talked to Elizabeth. I'd like to start seeing her twice a week, but there's a full schedule. That's right now. She just got to work that in, and I really do know that I've got to step it up, and I'm willing to do that. The reason I haven't been going to any meetings is honestly, I don't have a lot of transportation, and I don't.
You can walk to a meeting. There are meetings all over. You can walk to a meeting.
Well, I'm trying to find
I'm not,
a new one.
I am not gonna even hear that. Cause you know that's not true. You can walk to a meeting. There are meetings going on all over the place. Here's what I'm gonna do. In order to defendant is to report over to community corrections placement on Scram Tavern.
Thank you, Your Honor.
And I want you to get a sign-up sheet and have it filled out that you've attended an AA meeting every day from today forward to the adjourn date. You're to bring that with you to your adjourn date, and I want to see it.
Follow me? Miss a day, I'm putting you in. Comes back, take your hands out of your pockets. You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there.
Your Honor.
If it comes back with any alcohol in your system, you're going. I'm just going to let you know how I'm going to handle it. Because I'm not sure I should be giving you this chance.
Thank you, Your Honor.
Turn this to July 2nd, 2026, 9 a.m.
To report to committee corrections right now, Your Honor.
Yes, he needs to report right now. Don't leave here without going over.
Your Honor.
I have given him instructions.
Thank you, Your Honor.
Thank you.
Court calls case People versus Kenneth Perry.
David Kennedy, did Your Honor.
Good morning, Your Honor. Ashley Hannibal for Mr. Perry.
Your name?
Kenneth Perry.
What are we doing?
We'd like to set a preliminary exam.
Discovery is complete.
Yes, Your Honor.
You will have their witnesses available the 30th. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Great. Thank you.
Court calls case People versus George Henderson.
Anderson, on behalf of the people, Your Honor.
Public defender, not Carrie, I can review, Your Honor. On behalf of Mr. George Henderson, Mr. Henderson, state your name for the record, please.
George Henderson. Thank you.
1 second, yes.
Really? What are we doing?
Judge, we are setting this, no, we are asking for an adjournment.
What? You don't, what are you doing? Setting it for?
Setting it for an adjournment.
Sir, you're okay. You're fine. What do you want me to do with?
I got a green sheet, Judge. We want to set it, we want to adjourn this matter. No, thank you.
Sir, I'm going to adjourn your man. Huh?
Have contact with Mr. Henderson, try
Don't try to blame us.
I'm not. Right. Go ahead, what you in?
This is not your fault. It is all her, right? Yeah. Okay, remember that. Yep. He threw you right under the bus. July 9th.
Thank you, Judge. Okay, I'm gonna talk to you.
First day. Yeah, thank you. Said it. Calls the case of People versus Arnold Preston.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Preston. Would you please state your name, sir?
Arnold Preston.
Your Honor, we are requesting an adjournment. There is some outstanding discovery forensic interview. We'd also like to address Bob.
How long will that part of the discovery will it take to get to them?
I sent a signed executive order to Your Honor this morning, so
We sign up.
We have not.
We have.
yeah, holiday some more. I would assume early next.
All right. Then I'll adjourn the matter to July 2nd, 2026, 9 a.m. Esteban.
Your Honor, Mr. Preston works for Edge Facilities. He has worked at that specific location for years. He's worked for the family of companies a total of 3 years. He's the night shift supervisor. He is in danger of losing his employment, and he is asking that the court consider that and grant him a personal recognizance bond. He indicates that he would follow any orders of the court, including any orders regarding contact, or any other things that the court might think were appropriate to assure his presence. He is originally from Michigan. He did spend some time in Indiana, which is where the his children involved in this matter live, but he does have ties here in Michigan. And again, he's working, and this is where originally from. And he has his mother and other family here.
Response from the people.
Your Honor, this is, at this time, I would object to any modification in bond. This is a criminal sexual conduct matter concerning two of the defendant's minor children. And although they were some time ago, the defendant does have 2 previous CSC convictions on his record.
Thank you.
So given that information, given the defendants, of course, would have intimate knowledge of where the victims of the issues, things of that nature. Especially maybe checks to modification.
Motion for bond modification is denied. Bond will continue.
Thank you.
There.
Anything else?
Court calls case versus the Peter Beisha.
An assistant public defendant, Nick Berkovich, on behalf of Mr. Avesha, who should be appearing via Zoom. I believe he is under the Motorola.
What?
He should be under the Motorola.
That him?
If you remember, Your Honor, yesterday we had a similar issue.
Yes, we did.
But
Oh, we got you. We got you. We can see you now.
all right.
Your Honor,
Better than what we did yesterday.
yeah, we have made progress since yesterday, Your Honor. As indicated on the green sheet, I would be requesting an adjournment to have him work with my mitigation team to make a mitigation report to provide to the prosecution.
When did we adjourn his case yesterday? You didn't?
I believe it was the 15th, Your Honor.
15th? Okay. Then let me do this because the day-to-day seem back-to-back days work for him. I'll adjourn this out to July 16th, 2026, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you.
Your Honor.
Take care.
Thank you so much. Bye-bye.
You're welcome. Take care.
Bye.
Bye-bye. What he said. Wow. Okay, there. Okay. Let's get busy. Court calls case People versus Martez Richard.
Evan on behalf of Your Honor.
Oh,
Public Defender Jay Bellinger on behalf of Mr. Richard, who approaches.
decided to do something today. Oh, I'm just that. Never mind. My bad.
I Huckleberry fend my cases out, Your Honor. That means if you get them to think that painting the fence is a lot of fun, then you get them to go on the record for you. Great.
Sir, what's your name?
Martez Richard.
Thank you. What are we doing?
Your Honor, I am seeking to set this matter for preliminary examination today, and then I would ask to address the bond, both cases.
All right. Preliminary examination in these matters will be discovery is complete.
To the best of my knowledge.
People have their witnesses available the 30th, June 30th, 2026, 9 a.m. before Judge Barr. As to bond.
As to bond, Your Honor, we would respectfully request that Mr. Richard be released on a PR bond subject to any reasonable conditions the court deems appropriate, including a GPS tether. Mr. Richard, from my understanding, had an initial failure to appear, which we would argue was not the conduct of a willful disregard for this court's authority. At the time, he was homeless and did not receive notice of the court date. Since then, his circumstances have significantly changed, and he has taken significant steps to stabilize his life. He just completed substance abuse treatment, has been accepted into a sober living program where he now has stable housing in Ypsilanti. He also has reliable transportation through the sober living facility, eliminating many of the barriers that previously contributed to his instability in that regard. In addition, he also has significant family responsibilities. He's the caretaker of his disabled mother and recently welcomed a newborn into the world. A newborn, unfortunately, he has not been able to meet yet. He recently suffered a devastating loss, that of his brother, who passed away a few weeks ago as well, Your Honor. And so in addressing any concern related to public safety, he's fully willing to be placed on a GPS tether, comply with any additional bond conditions the court believes is appropriate. He's willing to utilize third parties for any necessary child exchanges, ensuring that there is unnecessary contact related to this matter, and fully understands the no contact order that's in effect. So we would respectfully be asking you to consider, please, a conditional release on a GPS tether and any other appropriate conditions that you might deem necessary.
So I'm going to object. according to my notes, failed to appear back in March of 2025. At the time of his failure to appear, he was present in court. The people brought up bond violations at the time for calling, texting, and trying to connect with the victim on Facebook. And after the court passed the case for us to try to get a report from YPD, when it was recalled, he had left. So I have concerns that he was present, heard about violating bond at the time, failed to appear, and was not back around until this year. I would have concerns that he comes back to court and his ability to follow court orders, especially given that it took him so long to come back, knowing he had left court against court orders. It was my recollection as I handled that case that day that the court was very clear that he needed to be at the courthouse and not. So I would have concerns. To move the objective.
How did he come into custody from the warrant?
I turned myself over to the police when they tried to get me.
Your Honor, my client advises that he turned himself over to the police. But how did that happen?
Yeah, it was. I was at. Want to tell him to.
You're at what?
Want to tell him to.
Yeah, you can tell him.
I was at the library when they approached me. They asked me my name and everything. And I told them my name, and I told
You didn't go to the police and turn yourself in.
I think he's arguing, Your Honor, that he didn't resist arrest at the time.
I will.
But that would have just been an additional charge.
Understood.
All right. I mean, but he didn't go knowing that he had a warrant. He didn't go turn himself in. That's what I mean.
I was just now getting stable, and I'm back stable now, Your Honor.
And I think part of the problem at the time, Your Honor, was that was the fact that he was without a home and didn't have a lot of notice in that regard. We had issues with contact early on as well.
And I just want to see my daughter. I haven't saw her since she was born because I was in here.
I understand that, sir, but
I will come back.
well, but you didn't before. That's the problem. And so I don't know that I can trust you to come back because I passed it so that you could talk to your attorney. I recall and get a cogent argument as to the bond violations, and then you just took off and didn't come back. Doesn't work that way. Motion for bond reduction is denied. Bond will continue as is. And after exam, maybe who's that before?
Judge Barr.
Barr will feel differently.
Okay.
All right. All right. Thank you.
We will address it before Judge Barr.
Courthouse case versus Curtis Jackson.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Davi Lebo for Mr. Jackson, who is on Zoom.
State your name.
Curtis Jackson.
And Your Honor, I did have some conversations with Jackson yesterday. He's indicated to me he'd like some more time to consider his options if requesting a brief adjournment.
Adjourned to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Courthouse. Well, yeah. Sharp is it? Oh, there it is. Court calls the case People versus David Sharp.
Joy Gaines, Senior Assistant Public Defender, with it on behalf of Mr. Sharp.
State your name, sir.
David Warren Sharp.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment. We requested some additional video discovery.
During the matter, will that be available soon? July 2nd, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case People versus Eric Jackson.
That's all the
I got to keep her mind yeah, Judge. Yeah.
Okay.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Would you please state your name?
Jackson.
Your Honor, Mr. Jackson has been working with our AIM division and had an appointment with the midnight specialist that he had to reschedule. We're requesting a 2 to 3 week adjournment so that we can get that letter done.
July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond continue. Court does call the case People first. Taiwan Grid.
At the bottom of the people matters. Issue.
Who? So they,
I can really honest, standing in for Miss Stephanie Cannon who stepped outside. Mr. Beginning for the record.
Juan Griggs,
Judge, I don't know if the court is in receipt of the documentation
the,
corrected,
yes, we have it. All right, and I believe she wanted, well, she's here now, finally.
I'm sorry, I was in the booth with Mr. Briggs. My apologies. We are asking that the 24 case be set for a preliminary exam. The prosecutor is working on discovery as to the 25th case, and the amended information or the amended forensic order is in with the court.
Oh, the 24 case you want set for exam, discovery is complete in that one.
Yes.
And people have their witnesses available the 30th.
I have not checked that date, but we'll try, Your Honor.
All right. So the 24 case that will be set for preliminary examination June 30th, 2026, 9 a.m. for Judge Washington. The other matter, what's the timeline on discovery?
Your Honor, I think it's either going over today or it went over yesterday, so very
Okay. And then I'll set that one, I'll adjourn the probable cause conference to July 2nd, 2026, 9 a.m.
Thank you, Your Honor. My client is asking that he allowed to be released to the care and custody of his sister on tether. She is trying to, she was his guardian. She's not his guardian anymore, but she is accepting him back to the house. He does want to go back into inpatient treatment. The court has signed an order allowing that. His Wayne County his Wayne County hold was cleared. They gave him a PR bond in that matter. And he has the paperwork to show the PR bond. He wants to go home. He has healthcare. He has SSD, I believe. So he has the ability to get into treatment. So he's asking that he be allowed to be released as well, and he'll go directly into treatment once he wants to take care of a few things. To be clear, he discussed his personal care. He's very he wants to get that together. There's things that he discussed with me, Your Honor.
Your Honor, I've addressed bonds several times on
Absolutely.
cases. I will note just if I recall correctly, the court did grant a release treatment for the needless objection, which is fine. But I will also note, and I think it's worth considering by the court, that the defendant did get the 2025 resisting and obstructing case the day after we missed court on the 2024 assaulting, resisting, or obstructing case. I think that if it's going to be anywhere that's not in custody, would need to be at a treatment facility because he doesn't appear to be able to remain law-abiding when he's out on his own.
I'm going to, at this point, as I have before, deny the request for bond. Bond will continue in both matters.
Thank you, Your Honor.
So, can I ask a question? So I would be released to treatment then?
No, the release to treatment is still in place. If treatment's available, if they get it bad, you'll be released to treatment.
Yeah, they told me that it'd be anywhere between this time and Monday, but
if it happens, then it will happen. But
it's the court is understands that you have been. He just wants the court to know that he has been screened, that in bed is available by Monday. He hopes.
Yeah, then if that happens, then he can go. I did that over the people's objections because the reality, Mr. Graves, that's what you need. You need treatment.
Thank you.
And so I'm willing to allow the release under those circumstances so you can get the help you need.
Thank you.
I comprehend.
And Your Honor, depending on the length of that program, if he is released on Monday, with our examination being on the 30th,
right?
I'm not sure whether or not he'll be available to come. So if defense counsel gets any information about that, they could let us know. So call us
and get that moved.
Yes.
Right. Thank you.
Information for him.
Court calls the case people versus Roderick Jacob.
Is that on behalf of the people, Your Honor?
So Hutchins on behalf of Mr. Jacobs, who's present and standing to my right, Your Honor.
My name is Roderick Jacobs.
What are we doing?
Your Honor, we're requesting an adjournment for additional coverage.
The public defender's office, that's what you're asking for, isn't it? No, I'm kidding. All right. How much time did you need?
It's It should just be a couple weeks would be fine.
July 9th, 2026, 9 a.m. Thank you, Turner.
Thank you.
In this packed court session, the judge handled a wide range of criminal cases, from plea agreements and bond reviews to treatment requests and preliminary examination scheduling. One defendant resolved a retail fraud case through a no-contest plea, avoiding additional charges while accepting responsibility for sentencing purposes. The most compelling moment came during a bond compliance hearing involving a defendant struggling with addiction and housing instability. After admitting to alcohol use in violation of court conditions, the defendant spoke candidly about personal loss, recovery efforts, and the challenges of staying on track. Rather than immediately ordering jail, the judge delivered a firm but measured warning, emphasizing accountability while offering one final opportunity to prove commitment to sobriety. Throughout the docket, the court repeatedly balanced public safety with rehabilitation, denying several bond reduction requests where compliance concerns remained, while also supporting treatment-based alternatives for defendants seeking recovery. The hearing highlighted a central theme often seen in modern criminal courts: the difficult balance between second chances and personal responsibility. In the end, the judge made one message clear: opportunities for change remain available, but they must be earned through consistent action, not promises